In 2023, the state of California passed a new law aimed at reducing incidents of workplace violence and to raise awareness of violence prevention among workers. Going into effect on July 1st, 2024, Senate Bill number 553, or SB 553, is an extensive regulation aimed at most businesses in the state. Why is this such a big deal? Well, according to the U.S. Department of Justice, an average of 1.3 million non-fatal crimes occur in the workplace across the country every year. And in California, in 1 year alone, 59 people were killed in incidents of workplace violence. Now, whether these threats come from fellow workers, customers, or other outside actors, workplace violence is something to be taken seriously. And this law outlines specific parameters for what your company must do to put policies into place to prevent it. But first, let's go over employers this law does not apply to, because there are a few notable exceptions. Those being healthcare facilities, which already have their own requirements under Cal OSHA's Violence Prevention in Healthcare Standard, facilities operated by the Department of Corrections and Rehabilitation, such as prisons, law enforcement agencies, as long as they're in compliance with the Commission on Peace Officer Standards and Training Programs, employees who telework, and finally, employers with fewer than 10 employees working at the place at any given time which aren't accessible to the public and are in compliance with the requirements of an Injury and Illness Prevention Program, or IIPP. Otherwise, all other employers in California must implement a workplace violence prevention plan. And what are the provisions and requirements for that plan? Let's look at those. There are 12 specific requirements of this law to keep in mind for your business. These items are aimed at putting a comprehensive workplace violence prevention plan in place. First, this plan must include names or job titles of the people who implement and maintain the workplace violence prevention plan for your organization. Next, you have to get employees involved in identifying, evaluating, and correcting hazards or risks. Employees should be encouraged to give their input from their valuable on-the-ground experience. They should also review the prevention plan once it's completed. And when you design and implement training, employees should be included in that process as well. Third, your plan should include the methods you'll use to implement your workplace violence prevention plan, and how you're going to coordinate among employees of the same facility or department. Next, your plan has to include procedures to obtain help from law enforcement agencies should employees need it. This should include contact information for law enforcement that applies to all shift hours and days, so any employee at any time can contact the police for aid. Also, you must have a written policy that prohibits the employer from taking any retaliatory actions against any employee for seeking help from law enforcement in the event of an incident. In addition to forbidding retaliation for calling the police, your policy should also include a prohibition on retaliation for reporting workplace violence to the company. In other words, when workplace violence occurs or an employee is worried it might be occurring, they have a right to report it to whomever they need to without any fear of retaliation. Now, once you have a violence prevention plan, it's important that you implement procedures to make sure employees in all departments actually comply with the plan. But creating the plan isn't the end of your responsibility as a company. You also need to have procedures for communicating in an ongoing way with employees regarding workplace violence issues. This needs to include procedures to develop and provide training on your plan. Next, you need to have procedures in place to continually identify and evaluate risk factors. This might mean surveying or utilizing existing surveys on things like incidents of employee violence in your field. Or maybe the threats for you are more on violence from angry customers, perhaps. Whatever the risk factors are, it's your job as an organization to assess and figure out those risks and then how to avoid them. Once you know the hazards of workplace violence for your organization, you need to implement procedures to correct them in a quick, timely manner. Don't just let potential hazards go on unchecked. It's your job to keep your employees and customers safe from such incidents as much as possible. If the worst happens and an incident of violence does occur in your workplace, you should have procedures in place to respond to and investigate the incident. Don't wait for something to go wrong before you decide how to handle it. You don't want to be scrambling in a time of crisis to only then figure out what to do and how to assess what went wrong. Finally, your policy cannot require that employees confront active shooters or suspected shoplifters. This is a major source of danger and injury in situations of workplace violence. In addition to these policies and procedures, which all should be incorporated into your company's prevention plan, your organization should be keeping a violent incident log. These logs should include, at a minimum, the following information about violent incidents that occur: date and time of the incident, location of the incident, nature of the incident, including whether the assault was verbal or physical, names of involved parties, including both perpetrators and victims, description of any injuries sustained in the incident, an outline of the response made to the incident, including emergency services responses, corrective measures made to prevent further similar occurrences, any follow-up actions such as medical evaluations, counseling, or additional training provided to employees, details on whether law enforcement was involved and if so, in what way, and any witness statements available. These records must be kept for at least 5 years. The last major new provision of this law is that it creates a means for employees to obtain temporary restraining orders, or TROs. These may be obtained from the court system when, according to the law, there is a credible threat of violence, which is a knowing and willful statement or course of conduct that would place a reasonable person in fear for their safety or the safety of their immediate family. These TROs cannot exceed 21 days in length, but they're designed essentially to allow employees directly affected by workplace violence to be protected from the person or people who have threatened them. In the meantime, you, as an employer, should, with your HR and legal experts, investigate and take action, especially if the person doing the harassing is another employee. So, these are the basics on SB 553 and the plan that you, as an employer, must implement, or which you, as an employee, should know about and have input on. These are among the strictest workplace violence prevention provisions in the country, with the aim of making all workers in California as safe and secure as possible in their workplace. If you have further questions, contact your HR department, security staff, or a California legal expert.